What?
Officers dispatched to a family disturbance and
Great.
detaining the suspect, the defendant. They frisked him for weapons and find a pill bottle with 4.5 bars of Xanax.
Does that mean that anytime there's a disturbance, they can just go up and start frisking and searching everybody? I mean, there's no, what the hell has he done wrong
Understand
to
that?
even justify a search? Really? You just say disturbance and then they start searching.
They were called out to disturbance from the den judge.
No. I'm going to find there's no probable cause to go forward with your case, Mr. Cruz. However, you still have an open felony warrant, have to take you into custody. I can't let you go. What'll happen is at some point you'll hit the felony court and you can talk with them, but I got to take you in. Okay. Just do me a solid and please, let's verify just to make sure. He has an open felony warrant. Mr. Cruz, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
So on April 15th, 2026, and this is for Cruz, correct, Judge?
Cruz, correct.
On April 15th, in Harris County, an officer dispatched to a family disturbance. Upon arrival, officer detained an aggressive and combative male suspect, the defendant. Officer conducting Terry frisk discovered a jar in the pocket of the defendant with no prescription and 4.5 bars of Xanax. The defendant advised that it belonged to the temple.
Good morning, sir. So your lawyer has let me in to know that there's I guess a snafu with your case. I don't know what happened. Essentially, what we do here is we go what's on record as far as in the computer system and how everything reflects in the system. You were eligible for pickup when all holds were released, which according to the system was on the 21st of this month, which was yesterday. So we give Florida 14 days from yesterday to come pick you up. If they don't come get you within the 14 days, Harris County releases you. We don't have to do 14 days. We do it as a courtesy just because our jails are packed to the gills and it's something that's gone on for the last 30 years. So we honor it here, but we don't have to. Statutorily, we can give them 30 days to come pick you up. That said, your lawyer here is saying that there may have been some kind of snafu upstairs with credit and whatnot. I don't know any of that. I have no idea. All I know, the system reflects the 21st and that's what we go on. Even if there was a problem and they backdate it to whatever it was, it would not be fair to try to hold me to them to the same standard. And what they would do, my feeling is they would probably ask for an extension for Florida to come pick you up, which I would probably grant just because there were so many, I guess, errors everywhere. Do you understand? What does he want it for?
He's wanted out of Leon County for 4 charges: burglary of a structure, criminal mischief over $1,000, possession of burglary tools, and attempted burglary of a structure.
Not only that, you've got the 4 charges out there. Your history here reflects you were charged with a felony. What was it?
Stop.
A felony stalking, false alarm. You've got a gun case, criminal mischief, violation of protective order, trespass, violation of protective order, 2 felony assaults. I'm sorry, a felony assault, a misdemeanor assault, and 2 other cases. I don't think it would be appropriate to give you a bond. Mind you, all those within the last 2 years. I don't think that it would be appropriate to set you a bond. Do you understand? Well, I will let your lawyer explain it to you. But essentially, you scare me, Mr. Malcolm, and I don't think it would be appropriate to give you a bond. Within the last 2 years, you've picked up 1, 2, 3, 4, 5, 6, 7, 8, 9.
I haven't been to Harris County since 2022. That's 4 years ago.
Okay. Well, here you.
I haven't been to Harris County since 2022. That's 4 years ago.
Okay. Well, here you have 2 cases from 2026 here in Harris County. And then you have 4 open cases, which are pretty dangerous in Florida. Due to all that,
It's a bit in the fucking thing. I got a misdemeanor harassment.
I understand that they got pled down, but nevertheless, 9 cases in 2.5 years or 2 years, whatever it may be. And then you've got 4 charges in Florida. It's just way too much drama for me. I don't think it would be appropriate to set you a bond.
So what about on my part where I signed for the harassment charge? For them to tell me that my time was gonna start on the 13th, then y'all backdoor, make it seem like I ain't get my time credit to the 20th.
So that's
Y'all
what,
just let it blow. No, I'm saying give more time to come get me.
that's what,
Only reason why I copped out for that because I wanted my time to start on the 13th.
I get it. We have no control over how the sheriff does the credit. It's up to the sheriff how much credit.
The judge told me that my
So-
time was served that day that I signed.
So what we'll do is I can set your case off for a couple days and have your lawyer here reach out to your felony lawyer to see what they can do to try
They're
to,
gonna stop my
work it
time. From Florida to come get me.
no. No, they have 13 days left to come get you though.
Like 12 now.
No.
It was the 20th.
What day did he waive?
Well, that was beforehand because that was pre-hold, but he waived.
Oh, so he waived beforehand.
It was on the 10th before the.
Got it. You were eligible for pickup. I mean, all the holds that you had were released on yesterday, the 21st.
I'm telling you, the 20th. The 20th.
It carries to the next day. Your hold, your time was done on the 20th. So on the 21st is when the hold is done. That's when
So
the
why-
time
why-
starts
why the
running.
Lawyer from the felony court telling me that it was over. on
I
13th?
cannot, I mean, I can't possibly tell you I don't know. I wasn't there. I don't know.
Don't you got the paperwork to prove that?
That's it. That's what I told me. She's gonna be following that. So then, you're saying, even with that, filing it, that does get extended. So now the date doesn't change. That's not gonna change something.
And I can't get no bond for it.
No, I'm not gonna set you bar. It's just way too much drama.
I was on the income, but I ain't never ran on every court date.
Got it. Nevertheless-
All
In 2 years, you've picked up
them cases were dismissed. I never got
14
a-
cases,
I only got,
13, whatever it may be.
I only got misdemeanor conviction. I have never got a felony conviction.
Okay, regardless. Nevertheless,
I appreciate you.
okay. Thanks.
I'll be right back. You good? You ain't got it from
I figured
the.
out, I can say it, I figured out what happened.
Point, Judge.
Hi, good morning.
Here, it's an extradition case, and really more than anything, kind of want to do a status update and I might need the court to maybe help on it in terms of understanding some things.
Sure. What's the last name?
Last name is Malcolm. First name is Dalen.
Shall we go ahead and just bring him out?
I'd appreciate it if I could really intro.
Okay, go for it.
So, just bring him up to speed. He likes to talk judge, but also there's.
He likes to what?
He's a talker judge. but
A talker.
there's also some trust
Aren't we all?
as well. There's some trust issues here, so essentially what happened was he pled out to a case up in district court, pled from a felony stalking down to a misdemeanor harassment. But the problem is there is a clerical error on the judgments where he wasn't given any prior credit for his jail time. He was on 43rd.
What?
This is where I disagree with the assessment, but I'll wait for it.
Okay,
When you look at the judgment, he was given 24 days, and which would have been a time served at 8 days times 3 upstairs. And contacted his felony attorney to say, hey, he finally got a time served, that when the clock would be started, Florida can tell us served it a month. The problem is that the judgment was incorrect, so it's filing a no pro.
none, yeah.
It
uh-huh.
hasn't been filed yet, from what I could tell from this, everything been accepted yet.
When did you do the plea? Dude, it's-
13.
So this is where I politely disagree with counsel. The judgment does say 24 days. I spoke with the felon chief up there. There's no issue with the judgment itself, which is why I don't believe the num is proper. What is possibly incorrect is how the jail was applied to his fin. which is a different problem because that's how the sheriff's office applied the judgment, which is correct. No one is debating that the 24 days is wrong. They're debating on how the 24 days apply because this court knows it wasn't always 3 for 1, before it was 2 for 1. It depends on how it's processed. And so.
Well, all that's up to the sheriff.
Right.
As far as 2 for 1, 3 for 1, 4 for 1, 10 for 1.
So that's the distinction here is because there's no issue with the judgment. He agreed to 24 days, he received 24 days. How it's applied is a different problem. As it stands,
Should the judgment reflect the credit?
well, no, because the credit is a separate part. And there are different provisions on how credit is counted, especially in terms, well, this is largely decided, but
Don't we normally put credit on a judgment?
not always. No, we can put the language in there
Don't
for
we
time
normally
served.
put credit on a judgment?
We
I thought
can,
we do.
Well, I think
Not all the time.
denying pretrial credit means a lot.
But,
We do, but maybe other courts don't.
well, so there's, and I could go into a rabbit hole on how the time, because there's a whole separate section on how time is credited. But again, no one is disputing the amount of days that's on the judgment. Because no one's saying 24 was wrong, it's supposed to be 23, et cetera. So separate issue. So how it was counted against the spin is it ended on the 20. And so obviously the differential for 7 days,
Sure.
when it actually shows the hold lifted, that's when our sheriff's office notified them and they immediately got to work. I spoke with both their sheriff's office and their DA's office, and they're ready for the original time within the 14 or 15 days as allotted from the 20 or 21st was when they happened. So the original pickup date would be by the 5th, the court date being the 6th. If it is as applied from the 20th when the release was.
That's beyond our scope of anything. Like, I have no control on any of that. We, and I'm assuming
Well-
Mr. Kim here tells the demanding jurisdiction the day for pickup ends this day because that's when the system reflects that.
Because the issue is if this court finds that he's clawed back to 7 days, then the last day for.
No, but I can't, how can I possibly do that?
In terms of, well, that's why I want to make sure everyone's on the same page.
I'm gonna go what the system says because I can't possibly go on what they say or what if I'm wrong? What if they're wrong?
I agree, Judge. I'm going
So-
on with felony defense counsel's saying that it was agreed on, because when he took the plea, his whole basis was, this is the time to serve, let's get me back to Florida. And that tracks with what the defense counsel said. So, yeah, 24 days was there, but 24 days is usually, because it's 8 times 3.
So really the 14 days started running on the 21st, which was yesterday versus
No,
the,
he's-
Well, arguably, my argument was, if everything had worked according to plan, it would have started working on the 13th.
yes, right.
Which would be
Right.
Monday would be the 27th, so.
I don't, you're gonna have to argue, or not you, but the lawyer on the case is gonna have to go argue with them about what and how and when and.
But I want to shore it up here because even assuming that, the 7 days are clawed back, I would reflect that in an extension request because of his history and with what he's charged with.
And I would probably end up granting it just because it's through no fault of their own.
Right,
You
and
know?
that's what, I want to get everything on the same page. Also, I also want to, in case I do need to make a bond argument, which I don't even know if you can pay a bond. I spoke with his mom,
It's
but
not,
is understood, Judge, but the door's still there.
do you want me to bring him out so we can explain
If
it?
you please, if we can, he didn't
Malcolm.
think something shady going
Yeah,
on.
for sure.
Two defendants, two very different situations. One consistent message from this judge: the system has rules, the paper has receipts, and good intentions mean nothing without compliance. The Cruz case is one of the more legally unusual moments you'll see in a misdemeanor court. An officer responds to a family disturbance, detains someone he describes as aggressive, conducts a frisk, and finds Xanax in a pill bottle without a prescription. Seems straightforward until the judge stops the proceeding and asks the question most people in that room probably weren't expecting. What exactly did this defendant do to justify being searched in the first place? No probable cause was found. The case was dismissed. And then, in almost the same breath, the defendant was taken into custody anyway because of an open felony warrant that had nothing to do with the case just dismissed. That is the law, operating exactly as designed, and yet it feels like a gut punch every single time. Then there is Mr. Malcolm Mara, 9 cases in roughly 2 years, 4 open charges in Florida, including burglary. A criminal history that prompted this judge to say, directly and without apology, "You scare me." Bond was denied. The pickup window for Florida was set. and a man who believed he had been given a time-served deal found himself arguing about credit calculations with a judge who could only go by what the system reflected. Was the credit applied correctly? That question may still be unresolved. But what is resolved is this. A record like Mr. Malcolm's leaves very little room for the benefit of the doubt. And in this courtroom, that doubt costs you. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns because justice never gets old.